Thank you, Mr. Chairman, and thank you, Director Cordray, for being with us once again. When I taught contract law, I'd cover arbitration clauses near the end of the term. And students usually came in thinking arbitration sounded so friendly and so inexpensive. But after studying the law, they discovered that arbitration stacks the deck against customers in favor of large corporations. Arbitrators often have a financial interest in remaining in the good graces of the corporation that places lots of business with them. Corporations usually hold all the key evidence in the dispute, but are under no obligation to turn it over. And an arbitrator's ruling cannot be overturned even if it contains clear legal mistakes or factual errors. So the bottom line is that when a customer thinks he's been cheated or that a bill is wrong, an arbitration clause in his contract makes it nearly impossible for him to get any real help. So it's no surprise that many big banks and other big corporations force customers to agree to arbitration clauses to get credit cards or open checking accounts, knowing that this means that a customer will have no real remedy if things go wrong. So, Director Cordray, as you know, Dodd-Frank requires the Bureau to conduct a study on these forced arbitration clauses and authorizes the Bureau to prohibit or limit the use of such clauses based on that study. The Bureau released the preliminary reports last December, and they were damning. Forced arbitration clauses are everywhere, particularly in contracts with the largest banks, and these clauses dramatically restrict the legal options available to consumers. I know there are additional issues that the Bureau wants to examine in its final study. When do you think the Bureau will have that study?
So I'd say a number of things. This is an interesting area where if you look at what industry says and then you look at what consumer groups say, sometimes there's some relation between the two. Here there seems to be almost none. And so, as I understand it, Congress waded into this area in Dodd-Frank in a way that is more interventionist than Congress has been on arbitration in other areas, particularly in business situations where the Federal Arbitration Act has been viewed by the courts as having a policy in favor of arbitration. Here, however, under Dodd-Frank, arbitration clauses have been barred from mortgage contracts flat out by the Congress. In terms of the other consumer finance contracts, as you noted, what the Congress has said very specifically and carefully to us, as the Bureau is, there seem to be very different views of this. We are going to direct you, not suggest, but mandate that you perform a appropriate study, comprehensive study, and make your best judgments about the pros and cons of arbitration clauses. And based on the results of that study, consider what policy interventions may be appropriate. The Bureau has been trying to carefully adhere to that. And frankly, if anything, we've erred on the side of a very thorough process, but I think that ultimately that's the right thing to do here. As you noted, we put out essentially an interim progress report where we covered certain subjects. We have more to come. I believe we have indicated that the further work on that, it is ongoing, it's very active, and I believe it will be completed this year. And then we'll be in a position to make policy judgments based on that. And I understand that some people think we should take forever on this, and other people think we should have finished it yesterday. I have my own views, but we're pushing along, and we're trying to do the work as Congress set it out in that framework, the two-step, just as they said.
All right, but you anticipate it's going to be this year?
I do anticipate it's going to be this year.
Good. I'm very glad to hear that. So I have a second question. Now, I'm sure you would tell me that you will need to see the final study before deciding whether to issue rules restricting or prohibiting forced arbitration clauses. So let me ask the question this way. What kind of evidence would lead you to believe that the Bureau should issue rules on forced arbitration?
It feels very much to me sort of like a case that's under advisement in a court. Clearly, I should not prejudge the issue of policy interventions before we've finished the study. We're well along, but we're not yet complete. Certainly, in the end, it's going to depend in part on things like how does arbitration work? Does it provide a meaningful avenue for resolution for consumers? Does it not? Why does it? Why doesn't it? Does it matter how an arbitration proceeding is procedurally set up? There's a variety of things that we're considering. The other is how does it compare to alternatives in court? I mean, I think we could all look at it and we'd come to about the same conclusions about what kind of evidence we think matters. But I'd really like to today here, if I can, stay away from trying to prejudge that.
All right, but I do want to be clear that if the evidence supports it, the Bureau is willing to issue rules regarding forced arbitration.
I think Congress gave us a very specific task here. They said, look at this very carefully, study it, tell us your results, and based on those results, you have an obligation to engage in policy making that appropriately reflects the conclusions you reach.
Excellent. I just want to say, I realize that arbitration can play a very important role in our legal system as long as parties choose arbitration freely after the dispute has arisen. But forcing customers into an arbitration system that banks control is just another way to tilt the playing field against consumers. The CFPB can help level the playing field, and I look forward to seeing the final report. Thank you very much. Thank you, Mr. Chairman.